All right, I just want to make sure I got the embedded on these, Avita. I don't know, she just said last time that all her, court ones are gonna be. No, I'm sorry. No, I get long? Things take it so long this
The
year.
instructions,
I know, but it just because of time.
I would have to look at the instructions too, so.
Okay, you know what, I'll read the instructions.
No, I'm just saying,
It's just a matter of time, I'm trying to get on in 2 minutes, that's all.
for what you. We can both go through it together, I just have to look at the instructions myself because it's not, I don't usually do it.
All right. All right, good to have the video too. Okay,
Under the current YouTube video,
I can do the YouTube video.
pardon?
Like, where is that to?
That's the YouTube video.
Right,
So underneath it, it says. You should see added video. You have to scroll.
what do you mean by
Scroll down underneath it.
okay?
Added video.
I have to do that afterwards, I guess.
Yes, good morning, everyone.
Morning, my lady.
Morning.
Thursday, the 30th day of September 2021, Court, Commercial Court 2, via Zoom at 10:01 a.m. before the Honorable Justice Sybil Williams, Civil Jurisdiction 2020, number 118, in the matter of FDG Electric Vehicles Limited and in the matter of the Companies Act 1981. Kyle Masters, Keith Robinson for the petitioner, Jennifer Hayworth for the JPL, Matthew Watson for the creditor.
All right, sorry, that background noise is actually on my end. There's something horrible happening with the air conditioning. Just give me a moment, please. Yes, thank you. Okay, so shall we just clear up appearances, please?
So it's Henry Tucker for the petitioner.
Yes, thank you.
Jennifer Howarth for the JPLs.
Yes, thank you.
Matthew Watson for LA's, the creditor.
Mhm. Okay. I have before me an application from the petitioner for an adjournment and a substitution application from the creditor. Which
Correct.
shall I hear first? Although both issues merge, it seems to me that they should be dealt with simultaneously.
Agreed, my lady. The position, and we confronted this in a recent matter, the position with regard to the substitution application is that if Mr. Watson's substitution application is granted, and the court is minded to subsequently grant a winding up order, he's required to, under the winding up rules, re-advertise as the new petitioner prior to the winding up order being made. And so with that, what we would propose is that you make his substitution application, and we will, and first, and then depending on the outcome of that, we turn to the adjournment application.
No, I don't think that that doesn't strike me as the most efficient use of the court time. They're the same arguments. The objections that would be made against the adjournment application are really one and of the same in terms of the arguments that would be made in support of the substitution application. I don't want to hear one application after the other. I think that you can just deal with both issues. And on that point, it does not seem to me that this is a matter that needs to extend past today.
I agree with
I agree.
I would even like to see it finished this morning, to be frank about it.
Yes.
The issues are, the principles are well known to the court. By all means, make your application at a reasonable pace that you feel that you can properly address a court, but let's not drag with this.
Yes, my lady. If in that case, why don't I proceed with our application for an adjournment, set out the basis upon which we say that the court has the jurisdiction and ought to exercise the jurisdiction to adjourn the present petition for a period sufficient to determine whether or not the presently proposed restructuring proposal is feasible and can be implemented for the benefit of creditors.
Yes, thank you.
My lady, as a starting point, we would just remind the court of the principles that apply in relation to considering an adjournment of this type. As the court will be aware, there have been a number of developments in the law, particularly in relation to Hong Kong listed, Bermuda Incorporated or Cayman Incorporated companies. The current the historical background is that and this is the case which ought to have been a tab 1 of our bundle, is that and that is the case of Up Energy at paragraph 5, that the court had a broad discretion to adjourn. And the sort of seminal case for where there were competing views between creditors as to whether or not a winding up order should be made was the case which appears at tab 2 of our bundle, which is Titan Petrochemicals Limited. And in particular, there's a number of reported cases in relation to that, which was ultimately a successful restructuring, is 2013 BDA LR 76. The circumstances of this particular matter were that certain creditors sought an adjournment of the petition.
Just 1 moment, please, Mr. Tucker, before you go any further. I have received various materials electronically.
Yes.
And I don't see what you sound as if you're describing an authorities bundle.
Yes, my lady.
Okay, well, that authorities bundle does not appear to have reached me I've seen the affidavit evidence filed. I've seen the skeleton arguments, and I don't, did you send an electronic copy?
Yes, it's been sent electronically, and it was also requested to be sent down in hard copy, which we also
Ms.
did.
Aswood? A moment, Ms. Aswood? Okay, I think she's coming to me.
Hi, I'm here.
Yes, thank you. I'm being told that there was a hard copy binder of authorities filed in respect of this matter, which has not been brought to me for my attention. I have been looking at the electronic documents that were forwarded on to me. Can you just have a look into that, please?
Okay, thank you. Would that be from Carrie Olson's office?
I put it-
Yes, well, the lady, could I just add, I sent one authority electronically this morning. That's the only one I proposed to take you to.
Yes, and I think I received, I do have some hard copy one. There's one from the Hong Kong Special Administrative Region, the High Court of Hong Kong, and there's also the Up Energy Authority that I think Mr. Tucker is referring to, but I don't have a binder of authorities.
I can have it sent again now.
And you can continue. I'll follow you and just make a reference to whichever cases you're referring to.
Okay, if you give me, I'll just send a message to somebody to send it again.
Thank you. Is it a small binder?
Yes, it's,
Can I see that? Can I see that, please? Can you, what case is that?
it's 4 authorities.
Okay, 1 minute. Thank you. Yes, this is what I want. Thank you very much. Thank you. Okay, I have it. Thank you.
Excellent. So we are at tab 2 of the bundle,
Yes.
which is the Titan Petrochemicals
Yes.
case.
Mhm.
And the relevant principles upon which we rely are set out in paragraph 11 of that judgment. And there, the court says, as far as the application for winding up order today is concerned, I have little difficulty in rejecting that application. And it goes on to cite Demiglass Holdings, which is a case the courts relied on repeatedly as to the principles which apply in the context of intercreditor disputes as to whether or not there should be a winding up order.
Yes.
And it says, as here, the battle is between creditors of the company, some in favor of a winding up order being made and others against it. There's authority for the proposition the winding up order will be made if a majority of the creditors support the petition and can only be refused if the majority support the opposition.
Yes.
For my part, I would not accept that the mere fact of majority support of making a wind up order would be an absolute bar in all circumstances of the court making an order. And then in paragraph 12, the Justice Kawley says the difficulty that the petitioner has in the present case is there's no credible evidence that before the court that a majority of creditors seek a winding up order. And that is why he says in 11, he has little difficulty rejecting the application for a winding up order. Now, the principles which apply to the adjournment of petitions generally have now been considered by this court on a number of occasions and been applied. And the specific case, which is now the leading case setting out, which is the circumstances in which a restructuring adjournment will be made, is actually a Cayman case, which is in the matter of Midway Resources International, and that appears at at tab 4 of our authorities bundle. And specifically, the often relied upon paragraph 50 of that judgment, which cites the Sun Chong, Fruit of the Loom, and CW Group Holdings cases. And CW Group, in fact, was another Kawley case sitting in the Grand Court of the Cayman Islands. It says that the Chief Justice summarized the principles to which the court may have regard when exercising this discretion, which is the discretion to adjourn for the purposes of pursuing a restructuring. It says The matters which the court may have regard is A, the express wishes of the creditors, though the court should be cautious not to count up the claims in supporting and opposing creditors. B, whether the refinancing is likely to be more beneficial than a winding up order. C, that there is a real prospect of a refinancing or a sale as a going concern being affected for the benefit of the general body of creditors. And the considered views of the board is the way to go forward. Here we don't have a board. The position is not that it's a refinancing. It's actually in this case a proposed restructuring. And so what we would say is that this is a very simple consideration for the court. The court needs to ask itself effectively 3 questions, and then answer those questions by reference to the views of the creditors. The first question is there a potential feasible proposal for the restructuring of the company? A. B, is that restructuring proposal one which would pay the creditors more in the event of it being successful than an immediate winding up order? And 3, whether or not the pursuing that restructuring is in the best interest of creditors. Now, the last one might seem redundant, but the reason it's applied by the courts is that the court, and Mr. Watson will no doubt address the court on this, but the court needs to consider the cost and time, the additional cost incurred by pursuing that restructuring proposal. So in the context of prior cases where the assets of the prospect of a restructuring is very, very low, and the cost of investigating that restructuring is very, very high, it may be that restructuring proposal is potentially feasible and may pay more, but the cost of and time to pursue it is so great that it's not in the interest of creditors to be pursued.
Mr. Tucker, it seems to me that I would be greatly assisted by being taken through the evidence of the support that there is from the majority body
Yes.
of creditors, which I think your client represents in terms of the restructuring.
Yes, lady.
Restructuring.
So,
And, and then, the timeline, if I anticipate that Mr. Watson will be arguing that a considerable time has lapsed, and we keep hearing about this restructuring prospects, it doesn't happen. And I think he even described this as a last minute, something in the terms of it being a weak last minute effort to restructure. So it would be helpful if you could maybe just get straight to the evidence that I should be looking at.
So, my lady, the evidence in support of the adjournment, and before I put this evidence in context, I think it's important to go to, it's the second affirmation of Joe June, and in particular, paragraph 5 of the second affirmation of Joe June, where Mr. June says, we received on 27th of September 2021 a proposed restructuring plan for the company from Shenzhen Ram Asset Management Company. Now, the petitioner's views on what to do at this hearing, and the consideration of the petitioner's views is founded upon a document which was received shortly before the hearing. What the petitioner says in their evidence is that at 7, it's expected that the restructuring plan will allow for successful restructuring of the company and its overall business, but as this will take some time to implement, the adjournment of the winding up of the company is requested. So the petitioner, who is, as the court will be aware from prior evidence filed in this proceeding, is a $130 billion asset management company, owned 70% by the Chinese central government, or Ministry of Finance, has reached the conclusion that this plan well, they say that it will allow for a restructuring of the company. So then the question becomes, and before turning to what the details of that plan are, the question becomes, well, what is the weight of those views to be attributed to our client? That can be seen, the most we would say the most recent identification of the weight to be attributed to that appears in the exhibit to the second affirmation of Joe June, and my copy, and in particular, it's at on the slide that's labeled 3.3, which is liability breakdown.
Okay, 1 minute.
That's page 11 of the PDF, my lady.
Thank you very much. Yes, thank you.
Now, my lady, if this is I believe the most recent breakdown of the liabilities of the company, and you'll see at the under at the debtors with, it says debt with pledge in the top left.
Yes.
So that's creditors who have some form of notional form of security, and I'll address you on that point in a moment.
Okay.
But the principal due to Sinopower, which is a subsidiary of China, which says it's China Oriental, but it's China Orient. There is the parent of Sinopower, the petitioner. It's 1 billion Hong Kong dollars in principal, and then on each portion of that, there's somewhere in the region of about 400 million in interest, which is due. The total debt due to China Orient or Sinopower, the petitioner, is 1.3 billion Hong Kong dollars. When that's compared to the grand total at the bottom right, which is 2.1 billion Hong Kong dollars, that represents 63% of the entire indebtedness of the company.
Yes, thank you.
But below, if the fourth line down, one can see that Elise, the creditor represented by Mr. Watson, who is seeking a winding up order, their debt is stated to be 282 million Hong Kong, or about, I will round it up to 283 million Hong Kong, which is approximately 12.81% of the total indebtedness of the company.
Thank you.
So,
I mean, I think that I imagine is probably not controversial. I glean from their submissions that they accept that they are a minority creditor, but the real issue, it seems to me, on the evidence is they would have to argue that in the exercise of this court's discretion, notwithstanding that the majority support is in favor of the adjournment of the petition and opposing the substitution application, I would, notwithstanding all of that, I would nevertheless grant their application on the basis that the restructuring plan that's proposed is not one that, viably speaking, would be beneficial to the overall body.
Yes, my lady.
I imagine that that's really what this is going to come down to.
Absolutely, Millie. And what we say is, and just to take you back, what we say is that Midway Resources sets out the exact approach which the court is to take, and Demoglass in Titan is to take when faced with a situation such as this. I mean, it is as you rightly point out, this is a situation where one creditor says this is not a feasible plan, it is not in the best interest of creditors, and another creditor says this is a feasible plan and it is in the interest of creditors. And the court can make its own, the court can understand and look at the proposal and see whether on its face there's anything inherently implausible about it or something along those lines. But ultimately what we say is that paragraph 50 of Midway Resources and Titan say that the court should defer in most circumstances to the majority.
Yes.
Who it is not disputed is our client. And the reason for that is because the majority is seen to be a good proxy, that it is assumed that they will act in their interests as unsecured creditors to maximize the value in the estate. And if a further adjournment were not in the interest of creditors, it would not be pursued. And in this case,
it would be very unusual for the court
to
go against the wishes of the majority of creditors.
Unless Mr. Watson can identify some sort of ulterior motive or reason why our interests as the petitioner in the present circumstances
something exceptional.
Yeah, precisely. And so what we say is that that's the test is clear. We say that the percentage of the overall debt of the company, which is owned by our client, is clear. And it's an overwhelming majority. But Mr. Watson faces another difficulty in his application. And what we would say is that that other difficulty that he faces is if one looks at the debt stack, excluding China Orient and excluding what Mr. Watson cannot identify is, and this is the same as in Titan, a single other creditor who is unsecured, who is appearing today saying they would like a winding up order. Notwithstanding, the JPLs have valiantly, in the face of not having their fees paid, to the tune of over $4 million US, continued to give updates to the committee, which includes many of these members. None have come forward to say, we'd like you to stop working on this without being paid, because we think that it'd be better if you just walked away and we wound up the company now.
In fact, you even go further. I think if I understood correctly on your written submissions, you go further to say that that Elise has not shown any evidence that an immediate winding up order would even be beneficial.
Indeed, and my lady, that's a very important point, because Demoglass says that in order for a winding up order to be made over the opposition of the creditors, it must be shown that there is a potential for a benefit. That's the key. There has to be a benefit from that. And if one looks, and it's actually important that I take you to this, because
okay,
in the fifth
sorry, just let me pause you there just for a moment briefly, please. Yes, thank you.
So on that point of whether or not an immediate winding up order will present a benefit to the unsecured creditors of the estate, paragraph 22 of the fifth affidavit of Matthew Klingerman which is filed on behalf of the JPLs, is telling. He says, the fees and costs that are liable to be incurred after the making of a winding up order are also likely to be substantial. Simply put, it's not an appropriate approach just to assume the company's cash will be automatically available to unsecured creditors. And then at 24, he says, through the 31st of August, 2021, the JPL's fees and costs are approximately $32.7 million. As of the date of this affidavit, the JPLs are less yet to draw a single dollar. It's clear that without additional funding or a significant realization made, there will be a shortfall. So what Mr. Klingman is saying, and it's not in the context of my submissions as to the benefit of a winding up order, but it's a factual assertion that without a significant realization being made or additional funding, which is precisely what is being contemplated by the potential restructuring plan, which I will take you to very briefly. The fees of the JPLs, which were properly incurred pursuing very serious proposals from well-known distressed debt investors in the United States, will exceed the total assets of the company available. And so an immediate winding up order has actually probably benefits the JPLs more than anybody else, in the sense that they are likely to be paid more quickly than anyone else. But they're likely to be the only ones who receive anything, i.e. the likely dividend in what that means is the likely dividend in a winding up scenario is zero to Mr. Watson's client and to my client. Now, Mr. Watson complains about the extent of the JPL's fees, but for reasons that I will quickly take the court to, there's no evidence at this stage that these fees were not properly incurred. It was a complex provisional liquidation where there were three main restructurings pursued, and those required significant time and cost. So going back to the key test, it needs to be shown that there's a benefit to the winding up. We say there's no benefit to the winding up because the JPLs who have more information than anybody before the court today say the likelihood is that nobody gets anything except for them at this stage. So we said no, there's no benefit to the winding up. And the JPLs themselves, to the extent that they're a creditor, their views should be taken into account. And they say an adjournment is in their interest. So that's the first thing. The second point now is that looking at the test in Sun Chong, we represent the majority of the creditors, and being the majority, the petitioner being the majority of the creditors and seeking a winding up order and seeking an adjournment of the winding up, we say that the court should accede to that application. And so when one combines, and we also say that there is a proposal which is feasible, and I think that's the other point that now I need to make good in order for us to sort of get home on the fundamental legs of the adjournment application. Now, it has to be said that this proposal, while it was received on the 27th of September, however, my understanding is that the discussion relating to this proposal goes back some ways, and the formulation of a credible structure that might be implemented was critical to determining whether or not the JPLs and indeed my client would today come before the court and seek an adjournment. It is wrong to say that come what may, our client was going to appear today and seek an adjournment. This proposal has come before the court, and so the first question when addressing whether or not it's there's really two things which we will address. One is it is said by Mr. Watson that there's been a series of restructurings, all of which were illusory, and now this is yet another one, and it's a day late and a dollar short. That's his first submission, which I will address briefly. But his second submission is that it is not feasible. Well, what we say is our client has reviewed it, and based on our client's assessment, we think it's feasible. We also point to the JPL's evidence, in which the JPLs state at paragraph 27, although the JPLs have some concerns regarding the restructuring proposal received from the Hangzhou investor, it is currently the only one available, and it may provide unsecured creditors with better prospects of achieving a meaningful return as opposed to a winding up. So the JPLs say, and our client does agree with this, that the proposal is not perfect. Indeed, it requires a serious amount of work in order for it to be formulated into something which can be executed. But it is certainly the bones of it are something which will give better prospects of a return than an immediate winding up order. So addressing the credibility of the proposal, I would just say when one looks at 27, you'll see that the Hangzhou investor, who is the person, the party proposing this agreement, it's actually a defined term. If one turns back to paragraph 12 of Mr. Klingerman's affirmation,
Yes.
one can see that the JPL's, Mr. Klingerman is discussing the steps that the JPLs have been taking in relation to the mainland restructuring of the company. The subsidiaries of the company. So there's an ongoing restructuring in the PRC, and he says the JPLs continue to explore the appetite of the investor attempting to restructure Hangzhou Changjian, which is Changjian is the factory in mainland China. If one turns to the exhibit to the JPL's affirmation, and in particular,
Is that at the bottom of the same PDF? Or is it in a separate PDF?
that is
Stuart might be able to.
It's a separate PDF, my lady.
MCL 5 is the.
Let's see. All right, let's see. Yes, I see it. Thank you.
If one turns to page 12, there is the second update of the joint and several provisional liquidators to the informal creditors committee of the company dated 9th of April. And this is the report made shortly before Mr. Watson made the present substitution application.
Yes.
And at page 16 of that, there's at paragraph 2.1, there's a summary, which I won't take you through now, but it's a summary of that factory, Hangzhou Changjian, restructuring, and the status of it. And it notes that it was put into a reorganization process in the PRC on the 14th of January. Now, if one sort of fast forwards to the latest update from the JPLs, which is on page 47 of the same PDF.
So sorry, just before we move on, I mean, the whole point of this is that I'm looking at the efforts that were made in respect of Changjiang. So
the point I'm making,
background, really.
No, the point that I'm making good here is that the party putting this forward is not some unknown, unnamed white knight who's had nothing to do with this company that's fallen from the sky, and does not have the ability to put forward a proposal which can be voted on and implemented in a restructuring in Bermuda. And the reason I say that is because if you proceed to paragraph page 47, I won't bore you with what has happened in the interim. It says, on 2 September 2021, so this is 3 weeks ago, the administrators, so the equivalent to the JPLs of the mainland China operation, put a restructuring plan to a vote of the creditors. Now it didn't pass, and it's expected that there's going to be a second vote in order for it to proceed. But a fully formed and viable restructuring plan, which was sufficiently advanced and capable of implementation to proceed to a vote in the PRC proceeding, was put forward. That you will see there's again you'll see the HZCG investor is mentioned there. It's the same party that is putting forward this restructuring plan in relation to the Bermuda entity.
I see.
So they've demonstrated their capability they are serious enough that they are able to work with a number of different parties. I mean, the mainland China operation is far more complex in terms of debt structure than the list co. And the final point that I'll just make on that, it goes back to our evidence, which is paragraph 6 of the affidavit of Joe Jun, where he says, the proposers of the restructuring plan have been engaged in the restructuring of the Hangzhou Chengjian vehicle business, which represents a core part of the business of the company. The restructuring of the Hangzhou part of the business began in January 2021, and through the due diligence and analysis that was carried out, the proposers realized it more beneficial to carry out the restructuring of the overall business, which resulted in this restructuring plan. So what Joe Jun is saying there is that it's the same investor, it's the same party, and that party has, after now having put forward a viable and meaningful restructuring plan for the mainland China operations. And if it's doubted that that's not a serious proposal, I can take the court through it. But I think it's self-evident by the fact that the court's put it to a vote. And that has concluded that it would be more beneficial that they have an interest, a concurrent interest in concluding a restructuring of the list co, which sits on top. And that is this proposal. So, my lady, that's
very helpful. Thank you.
That is, I would hesitate to take the court through the actual proposal in great detail. I no doubt Mr. Watson will criticize.
I was just going to say, I don't think that, I think I should probably hear from Mr. Watson as to what his complaint is, and then you might address that in response, as opposed to just exploring what might be his complaint.
Yes. Yeah. Thank you, my lady. If you just give me one moment to make sure that I'm covered. My lady, I think that covers the core of what we say is the basis upon which the court should exercise its jurisdiction to adjourn. All I would say is that if the court has any concern about the length of the adjournment sought, there's actually 2 points for the court on the length of the adjournment sought. The first point is that our client is continuously evaluating, as any rational creditor would, whether or not it is in the interests of the estate to continue this. And so if the court were to be minded to give a shorter adjournment for the proposal to be investigated, that's not something that we would object to. And the second point that I would make is that no one, including the investor and the petitioner, is proposing an indefinite adjournment here. Mm-hmm. This will not go on forever. And the reason is that the company will be delisted. if there is no restructuring proposal consummated. And what we say is that that effectively that is the backstop date, which I believe is 1st of January. It's in January 2022. From our client's perspective, we agree that this is a proposal that comes late in the day. We're disappointed that the prior proposals, which frankly would have produced a potentially $1 and $1, were not consummated. Those were not consummated for reasons that can be drawn to the attention of the court, but had nothing to do with the feasibility of the actual proposals themselves. But now we have a proposal from an investor with a clear, first of all, that has identified themselves before the court. Second of all, has demonstrated a clear ability to bring a proposal to vote in order to restructure the operations of this very company. And three, is realistic about the timeline in which they need to do it, i.e. before the delisting in January 2022. So that's the timing issue that I just wanted to clarify, to box in what we're saying here.
Okay.
And that concludes our submissions on our application for an adjournment of the petition.
Thank you very much. Does it make sense for me to hear from you, Ms. Hayworth, before I move on to Mr. Watson? Do you want to add anything or?
I think, to be honest, my lady, my learned friend has really, especially because he's gone through one of my clients' pieces of evidence, he's highlighted a number of the points that I wish to make at this relevant time. Yeah. There are maybe some additional points to be made, but I think they almost take us down a different path. So I think it's probably best if we hear from Mr. Watson.
Okay, thank you very much. Mr. Watson.
Yes, good morning, my lady. I obviously appear on behalf of Elise. My lady, as you noted at the outset, that the principles on this matter are well known, but what is important is that the application must be decided by reference to the evidence. Mm-hmm. And that's important, my lady, because the court obviously made directions as early as April for the hearing of the petition and the substitution application. On any view, my lady, it is obviously a disappointing state of affairs to be landed with evidence less than 24 hours before the hearing. It's obviously disappointing, I would say, from the court's perspective, to be landed with that evidence. But the effect of it, my ladies, is that my client has obviously had no opportunity to put a response into it. Mm-hmm. My client's a Taiwanese listed company. There's obviously a significant time difference. And so to receive what is obviously an important matter on the doorstep of the hearing, I would say unsatisfactory on any view. That, of course, impacts the evidence the court has. I don't propose to take you to too many authorities, my lady. That there's just one section of Up Energy I'd just like to draw to your attention. Mm-hmm. And then the Hong Kong case, I would say, is instructive to you on what type of evidence you should be looking for. Yeah. So if I can just briefly take you to a couple of passages. So the only paragraph of Up Energy I'd like to draw to your attention is paragraph 4, my lady.
Mm-hmm. Yes.
And so that sets out, my lady, that the point would seem to be tried to be made against us that we needed to establish some benefit, my lady. I don't think anyone's saying to you that the return to unsecured creditors is going to be zero. There's obviously lots of things that would have to happen in a winding up, my lady. A winding up order doesn't necessarily prevent a restructuring altogether. It may be more difficult, but of course it's still possible to restructure when you go into liquidation. Mm-hmm. Mr. Klingerman's affidavit has highlighted the possibility of claims, my lady. So of course, that is something that the company would consider. And the benefit of a liquidation, my ladies, is that it brings structure to the process, because you can have things like a formal committee of inspection, which will give direction to the company. I would say that there's some quite clear disadvantages of having an informal committee of creditors. And I'll propose to take you, to some of them in light of the history. And the history, I say, is very important, my lady, because what you won't see in the cases that have been put to you is, the undisputed fact that we've already been 18 and a half months in a provisional liquidation, 14 of which have been with the JPL's full powers. On any view, creditors have been patient. All you have today before the court is you have one creditor who's supporting an adjournment and one creditor who's opposing it and seeking a winding up order. No point can be made against my client that because others are not coming in behind me, that is some disadvantage. I would in fact say it's more disadvantage for Mr. Tucker's client, because obviously what you need in a restructuring is 75% of creditors to have a scheme of arrangement. If you knock out my client as not in support of it, well, you're looking extremely thin, my lady. And so, as I say, 18 and a half months down the track, if creditors were seriously intending to be behind it, and the proposals, seems to have been known in advance of the hearing, obviously for a very short amount of time,
Sorry,
then
can you give me those, let's look at those figures. Your client represents, as I've been told, something akin to 12.81%.
yes. My lady, can I say before we jump into the figures, that there are some facts that I'd like to draw to your attention, which I say we're not confident that those facts are accurate, my lady. I'm going to take you to some evidence why I say that. And it's for some very obvious reasons, my lady. There are no current management accounts before the court. That's number one. Yes, I accept, audited financial statements might be difficult, but the evidence shows that the company is already significantly behind producing its financial statements as required by the listing rules. The current provisional liquidators picked up the accounts on, roughly 23 July. I'll take you to the evidence in which we're being continually asking for information and continually asking for updated lists of creditors. And then what's put to you before the court this morning is a list of creditors within a restructuring plan. And that's why I say the directions the court made were important, my lady, because everyone has had plenty of time to look at Mr. Chang's affidavit, the correspondence in response to it, and they could have put before the court a lot of the concerns that I'm raising. And so that I say is one of the main disadvantages of trying to lob evidence before the court. That is something when I show you Mr. Chang's affidavit, you might have expect evidence would have been put on in accordance with the directions, and then the scope of the dispute we're talking about would be having regard to what's been said in response, together with now looking at the restructuring proposal. And that's why I hesitate to say to you, my lady, just don't take that in an isolated snapshot. You need to look at some of the things I say have arisen in correspondence and where we are today.
But where does that take you? Where do I land after I look at all those things? Where does that?
Yes,
really
where ultimately landing is this, my ladies, is that parties have had a very, very good opportunity to put evidence before the court. That's quite clear from the court's directions. And you could be looking at this proposal with the benefit of all that background information had it been properly presented to you. And so I say that coming to court on a very last minute when you strip out a lot of the cover pages on the restructuring plan, you're probably only looking at 5 slides of information. But without having accounts, without having proper context to it, when I show you the Hong Kong authority, what you're ultimately looking for is whether this can turn around into a viable business and the company won't still find itself in a situation of insolvency. And so just looking at the restructuring plan in isolation might sound very good in a few glossy pages of letters, but there's no meat to it, my lady. Whereas if you had the totality.
Do you accept, Mr. Watson, that you're asking the court to impose a view in substitution of, or in place of the view of a majority body of unsecured creditors?
I accept, my lady, that the evidence tends to suggest that they're a 50% creditor. How much over 50%, what one can probably debate. What is obviously clear to you is that you don't have evidence of 75% of creditors before you're supporting any restructuring proposal.
Yes, but do I need to have, I mean, do the authorities not suggest that the court, in the context of an adjournment application, doesn't need to see up to the 75%? It just needs to see that there's likely, and you would do that by having regard to whether or not there is a broad majority. And if there's a broad majority that's in favor of an adjournment for the purpose of a restructuring, the court does not have to. I'm quite sure I made those points in, it would have been Up Energy, and there's another case I did. Is it North
Mining Shares Company, my lady.
Yes, thank you.
Yeah, but the difference in this case, my lady, is that a lot of the times these matters present themselves is, number one, when a company goes into liquidation, things happen very quickly. And of course, you don't have time to muster a 75%. And so, of course, if the majority comes along and says this is a reasonable proposal, the court, in the exercise of discretion, may be willing to give further time to do that.
Mhm.
I think it's quite important not to forget that we're 18 and a half months on. And as I say, you're not here today with Mr. Tucker saying to you, well, there's some other creditors in our camp. I'm going to say to you, when we look at the proposal, one of the central elements of it is a restructuring of Elise's debt, and we don't agree to it. So if you take us out, my lady, as I say, where is the support to get to 75%? To us, it looks very unrealistic that you're ever going to achieve that.
But do I not have any evidence of the position? So I have no evidence of the position of any other unsecured creditors.
Correct. Yes, and that's essentially the point, my lady, because of course you're deciding the application on the evidence before you. But if I can take you to next, my lady, just the one
Sorry,
remaining.
1 moment before you go so far. Do you so do you say that it is misleading to say that the 63% figure given to the court of the entire indebtedness of the company in the context of a restructuring, you say that that's inaccurate?
Well, all I can say is that because there are no current accounts before the company, I can't tell you for certain that that's the position, my lady.
How
But
should I treat that? How should I treat that evidence?
With some skepticism, I would say, in light of what we've been asking for. I'll take you to it, and hopefully it'll become very clear, my lady. But before we can hop on to that, can I just take you to the one remaining authority, the Hong Kong authority?
Yes.
Yes,
I'm
please.
obviously more keen to see the evidence, but fair enough. Let's look at what the
Yes.
principles are first. So what's the authority you want me to look at?
Yes, can I take you to, if we can start at, there's a paragraph 5, but jump down to paragraph 51, it's numbered in the case.
Sorry, what case am I looking at?
The Hong Kong case, my lady.
Okay, thank you. Paragraph 5.
And this is what it says, my lady. If the creditors are taking different views, the court will normally take into account all the circumstances, including the following considerations: the qualitative assessment of the number of creditors for and against the winding order. It is not just a matter of counting the number of creditors in favour and those against, or the proportion of the value of the debt they hold. B, the reasons pro-offered by the supporting and opposing creditors. And of course, C is important, the feasibility of the proposed restructuring. If I can take you down to...
I'm looking at, you've told me paragraph 5, when it starts, I developed this further.
Yes, and if you go down, you'll see a paragraph number 51.
Oh, yes, I see. And where did
and
you
I was
get these
reading-
from?
Yes, and I was reading from subparagraphs A, B, and C of that.
Oh, I see. Thank you.
Yes.
Yes.
If I could take you to next, my lady, there's a subheading in purple, the evidence required to satisfy the court an adjournment is justified.
Yes.
Could I ask you to read from that to the end? It's only a couple of pages, my lady, but I would say they're quite important observations.
Okay. Yes.
Yeah, so we'll just emphasize a couple of points, my lady. So one of the points that's made, in order to satisfy the court that a petition should be adjourned in order to give the company the opportunity to address its financial problems, is necessary to adduce evidence explaining how the difficulties arose and how they'll be addressed, not just in the immediate term, but also by explaining how the company will return to financial viability in the short to medium term. Well, of course, my lady, you don't have any evidence of that. What you just have is, in effect, a concept with, it's a slideshow presentation, my lady, without, as I say, any meat to it, my lady. And in this case, I would say draw some parallel. What was put, it seems before the court in that case was a very simple memorandum of understanding. And the court has said, well, on that evidence, it's insufficient. And of course, the concluding paragraph, my lady, Justice Harris is obviously a very experienced winding up judge, has recognised that this problem is all too frequently occurring, my lady, that parties show up to court, in this case, literally on the doorstep, put some evidence before the court. For my client, obviously, they don't have an opportunity to respond to it, and ask for an adjournment. And I say, my lady, that because the court has made directions, and because you're dealing with a listed company, everyone full well knew, my lady, that this occasion was coming up before the court. But that's all I wanted to address you on the cases, my lady. If I can dig into the
Yes.
before I take you to the restructuring proposal, I'll just gallop through. Can I take you to the exhibit to Mr. Chang's affidavit?
Yes. Thank you. Yes. Thank you.
Yes. Can I pick it up, my lady, at page 40 of the exhibit?
All right. Just one moment. I don't know why it's not opening. I'm being refused access to it. It says Windows cannot complete the extraction. Destination file could not be created. I don't have any problem opening up the other PDFs, but for some reason,
Okay.
does it have some sort of protection? That might. Let's see.
Sorry to interrupt, but I just wonder if, my lady, you may have a hard copy of this, because I think it was filed some time ago. I don't know,
I can
Mr.
tell you
Watson, if
that
that's
there's
correct.
a
That's
minimal
right. Yeah.
amount of paper in front of me. And I didn't complain about that because I did want to look at the documents electronically instead. But if it was filed, then I can request it. But does that have to stop us? Is that something that you can just?
No, it just make it a little bit difficult for you to
Let
follow.
me
But
make an inquiry then. 1 moment. Ms. Oswood? Would it have been filed in a binder or would it have been placed directly in the court file? How large is it?
well, this came in during COVID, my lady. So I'm not sure whether it made its way in hard copy actually, but I can try to send to Miss Aswood.
Okay. Yeah, it's definitely not on the court file of hard copy documents.
Okay. Can I
Do you want
take
to
it
take
to
a
the
short break and then try and see if you can get that to me, and then we can come back in 10 minutes?
yes, we can do that, my lady. Thanks so much.
All right, so let's come back at 10, at 11:15.
Yes, I'll email to the court now.
All right, thank you. Mr. Watson, I just want you to know I've just been able to open it.
Oh, perfect.
Okay,
Great.
so you
Thanks,
can
my
still
lady.
come back at 11:15, but you can take a break. No, I do have it open. Thank you.
Oh, perfect. Thanks so much. Appreciate that.
Yes.
my lady. Yeah, can I please start at page 50 of the exhibit? I'll endeavor to gallop through this as quick as I can.
15
50, thank you, my
or
lady.
50, thank you.
Yes.
Yes.
My lady, this is the final page of the first report from the JPLs of 15 December. And as you will see, it's just a statement of the cash position. But I just want to show you quickly how matters have evolved. You'll see in the top line, the bank balance is at 27 July 2020 was 3 million, and then it's reduced only 100,000 at this stage. And then you see in note 1, a very simple statement saying professional fees of JPLs have not been settled.
Okay.
Do you see that, my lady?
No, because I don't. Hold on.
Oh, sorry, 53, my lady. I said the wrong page.
53.
Yes, my apologies.
It's 54 of the PDF.
Thank you
I'm
very much.
54. Thanks.
$54 is an email, and it looks like you might be referring to 53.
Yeah, so the page before that, my lady.
I'm looking at a chart of bank balances as at
Yeah,
27th
that's correct.
July.
That's
Okay.
correct, my lady. And I just want to show you how the finances have evolved. So at that stage, my lady, there was a current bank balances at 3 million. It's dropped 100,000. But the important point is note 1 for present purposes, my lady. We're simply told at that stage, professional fees of JPLs have not yet been settled. And then if I can take you to the following page, the email you were on.
Yes.
And can I ask you to read the 4th paragraph down saying we request that an updated report be provided. And then there's a whole list of information that was sought.
Okay.
Subparagraphs A through to G.
All right. Page 54. Yes, is that familiar to me for a reason? Have I been shown this before?
Yeah, I was wondering if it might have caught your eye because we sort of glanced at this very quickly when we had an argument before
Yes.
you granted, I would say generously, a 3-month adjournment while I was trying to keep them on a tight rein for a 1-month adjournment.
Yes.
Yes. And so if we skip over to the next page, the JPLs in the 3rd paragraph said, that email is noted, we'll get you a report during the 1st quarter.
Yes.
And then following that is a letter from Cox Hallett on the 14th of January.
Yes.
It's a lengthy letter, my lady. The next sort of had 3 pages in total, but what you'll see here is a consistent pattern of trying to follow up on information. I can sort of skip through to if you go to page 64, my lady, that's when the next report of the JPLs comes out. We're now at 9th of April. But what you'll see from that initial email I've taken to you, my lady, very minimal of that information actually comes to hand, but I'll show you what financial information gets produced in each report.
Okay, so I'm looking at the 9th of April report now.
Yeah, and if I can take you to page 77 of that, at the top right-hand corner says page numbers.
Okay.
And if I could ask you to read 5.2.3, and what the JPLs are saying at this point in April is that the JPLs consider that the development in the next 1 to 2 months will be crucial to the company. And as by then, the JPLs are able to obtain a clearer picture on the prospect of restructuring the group as a whole, or the prospect of a standalone restructuring of the company.
Yes.
And then the following page, my lady, you then have a table of liabilities. The JPLs are saying this is as of 23 July 2020, bearing in mind that we're in April 2021 at this stage. But I can ask you to read notes 2 and 3, my lady.
Okay. Yeah.
That's part of the reason I say, my
So
lady.
you say that you can't rely on this information.
Well, the JPLs themselves are, the JPLs are themselves saying that. And of course, note 3 is telling you that there's a 312 Hong Kong million of an intercompany payable, and you don't see that liability reflected in the table above or in the restructuring plan table of liabilities that you were taken to.
Mhm. You're seeking to be substituted as a petitioner and
Yes.
an immediate winding up order.
Yes.
How does that assist the general body of unsecured creditors?
Yes, I say this, my lady, in short. One, obviously, 18 and a half months has transpired. Obviously, no restructuring proposal had come, but for yesterday, effectively. 2, you have to look at whether it's viable. I say on the present evidence, it's not. 1, and I'll take you to it in a second, Elise's debt is proposed to be restructured, and Elise doesn't agree to it, my lady. That of itself, I would say, is fatal. The third thing is you don't have, as I say, 75% support of creditors after 18 and a half months. Finally, my lady, I've showed you what is said in Up Energy. The test for benefit is a low one, my lady. No one's saying that creditors are not going to receive nothing. There are some obvious.
Mr. Tucker, I thought I heard him quite clearly say that you're looking at 0% of any sort of, there'll be no dividends after, if there were to be an immediate winding up order. In fact, the only parties that would benefit would be the JPLs in terms of their fees.
Well, I'm not sure where exactly you find that on the evidence, but I'm trying to take you to, my lady, the absence of accounts. That's where we're sort of on at the moment. And of course, that's important, that if you had a proper set of accounts, my lady, and if you had a proper analysis done of this is what the proposal would look like, if you had this type of restructuring, this is a proposal it looks like. If you head down a winding up order, you'd very clearly see the analysis. As I said to you earlier, Mr. Klingerman's affidavit points to the possibility of claims. Yes, they may need to be funded, my lady, but it's not as though that on the current evidence, anyone is saying this is a zero recovery. I also said to you, my lady, that if you're going to restructure it, winding up, it doesn't necessarily shut out altogether the possibility of restructuring. Yes, it may create it more difficulty for it, but to say that there'll be zero benefit, my lady, I don't think you can say that with full confidence by reference to the evidence.
Can I say with full confidence that there will be benefit?
Sorry, my lady?
Can I say with full confidence that there would be a benefit?
Yeah, I've just tried to. Yes, I've sort of identified to you what the benefits are, my lady. As I say, restructuring doesn't necessarily go out the window. You can investigate claims. You don't have a set of accounts before you that would say there would be no benefit. There'd be, as I say, there'd be benefits of a formal winding up. You have a proper committee for inspection, for example, my lady. Obviously the issue.
Let me just make sure I'm not misunderstanding. You said a restructuring would not, the possibility of a restructuring would not go out the window if there was an immediate winding up order.
That's correct. Of course.
You're referring to an entirely different the possibility of a different restructuring plan, or?
Yes, I was saying in generic terms, my lady, a winding up obviously doesn't preclude a restructuring happening. Obviously, we say that the current proposal is not a viable one, but if you put the company into liquidation, yes, I would say it probably becomes more difficult generally, but it doesn't shut out restructuring altogether.
In principle.
In principle, yes.
Okay.
And so when you're looking at the question of benefit, my lady, as I say, it's difficult for you to grapple with that on the evidence, I would say, for the reasons I've said. You don't have accounts. There's possibility of claims mentioned. And when you get into a winding up procedure, things are dealt with formality, and you see what the result is. One ought to forget, my lady, that my client has a $36 million debt. It's obviously a very unfortunate state of affairs. And so what that commercial reality alone, my lady, my client's taking a preference of going into winding up versus the possibility of this proposal, in light of the background that up until yesterday there was probably going to be no dispute that we were going to have an argument about whether the company should go into winding up. But as I say, patience is sort of being tested. It comes to a point, my lady, that you can keep further putting this company into a hole by incurring time and costs on JPL's fees, looking at proposals, or you can start to go into a winding up and look to do the best you can and quit it. And that's the course my client seeks to take.
Would I not be very much reliant on the evidence of the JPLs, where the court is faced with differing views as to the benefits of the restructuring plan on the table?
Yes.
And the effects of an immediate winding up order on the other hand? Would I not, in those circumstances, attach real weight to what the JPLs have to say about what the likely benefit would be?
I think, my lady, that I don't think anyone is suggesting to you that you ought to shut out anyone's views. Of course, they ought to be taken into account. The weight for them is a matter, I think, where you need to exercise your discretion, looking at the evidence before you. And I would say, and we'll turn to the restructuring plan in a moment, it's very light. And even the JPLs have put evidence before the court, and you would have seen it in the skeleton argument, where they have serious doubt as to the viability of the proposal. And there's sort of very bold assertions saying things like that there's a lack of working capital. We have concerns that it'll be viable. My client is looking at those statements without the benefit of what the JPLs know. And of course, as I say, at least restructuring of its debt is a component, and we don't think it's viable. As I say, I think ultimately it comes down to a question for you as to whether the evidence before the court, in light of the cases I've shown you, satisfies you an adjournment is appropriate. And as I say, none of the cases you've looked at deal with the situation in which it's already gone 18.5 months. You've had proper directions for the filing of evidence. And I would say clearly a lot more could have been done if it was the case to satisfy that there's an adjournment. Even on the petitioner's evidence, my lady, what do you get from the petitioner who's got all, a lot was said to you about how big they are and a lot of money at stake, but you've got 1.5 paragraphs or 2 paragraphs. to us, that's not convincing. It looks to be knocked up fairly last minute, my lady. As I say, these are all evidential matters for you to weigh up in the balance. I think the only two things I'd like to do, my lady, I don't want to spend too much time on it. I think we should try to wrap this up before lunch. I'd just like to spend a couple of minutes on the restructuring proposal itself.
Yes.
And then just address you in the alternative that if you're not with me on substitution and winding up, what I say ought to be done about that.
Okay. Thank you.
Yes, so if I can take you to the restructuring proposal first, my lady.
Yes.
Can I take you to can I take you to page 15, please,
Page 15.
of the slideshow presentation?
Oh, sorry, I have that. in hard copy. Yeah. Yes.
Yes, so you see on this one page, my lady, that the core component
Sorry,
of
my
the
counting
restructure,
pages are not numbered.
the bottom right-hand corner, it should be debt settlement plan 4.3, other debtor.
4.3. All right.
Yeah.
Oh, yes. Thank you.
So you see there, my lady, that the whole page is devoted to how it's proposed that Elisa's debt should be restructured.
Yes.
And the plan is, well, there's three plans, but plan one is FDG's debt to Elise will be transferred from FDG to FDG Kinetic. And for this, FDG and FDG electric vehicles will need to negotiate specific terms, including, not but limited to, FDG Kinetic's debt to FDG of 49 million and transfer of the Chunjay ownership from FDG to FDG Kinetic. So on this page alone, there's quite a number of components just to restructure Elise's debt. No one has approached Elise to say, you know, is this workable? I'm telling you, my lady, that by submitting to you that this is not satisfactory to Elise. And so if that's the case, my lady, and no one has submitted to you that there's a way to force this down Elisa's throat. It's obviously involving, on that aspect of a loan, many different entities. Then the proposal doesn't work, my lady.
Mhm.
And so that goes to the question of whether it's a viable restructuring plan. And if you can't be convinced that it can be done without Elise's will, then it's not a viable proposal.
You say that it cannot be done without Elise's will because of the significant percentage that you say that
Well,
you have, or
I'm not sure it's just as simple as that. You know, in a scheme arrangement, obviously needs 75%,
yes,
but they're also looking to, it seems, assign Elisa's debt,
yes,
which derives from a convertible bond,
yes,
from FDG to FDG electric vehicles. And no one's putting evidence before you that, you know, that can be done. As I say, that this is just one component of a.
Can that not be done without your consent? With your client, without your client's consent, the assignment of that debt?
I'm not submitting to that to you. No one's putting, I think that's seeking to reverse the burden of proof, my lady. No one is putting evidence to you that can be done.
I see. So I should start out with a presumption that that cannot be done.
The
And
current
then it
evidence
should
before
be-
you.
And then I should have evidence to show that how that could be done, whether or not Elise consents.
Indeed, my lady.
Right.
But just to try to be realistic about it, my lady, that I just want to take it at a very high level. You have FDG Electric Vehicles at the top, who is in provisional liquidation with full powers. The other subsidiary, my lady, is FDG Kinetic. That's been put into winding up in the Hong Kong court. And then you have multiple subsidiaries in China that are in formal bankruptcy procedures, my lady. The multifaceted nature of this proposal, looking at it, whether it's actually realistic, requires all those various different components, my lady, ultimately to come out of formal insolvency procedures and back into a profitable business. And that's sort of why I took you to the Hong Kong case, my lady, because it brings a bit of realism as to the types of evidence you need to establish that this is actually going to turn around. As the Chinese subsidiaries, the operating subsidiaries, they're not functioning, my lady. And so, you know,
Yes.
yes, and it was sort of picked up in the skeleton, my lady, that, you know, it's been pointed out to by the JPLs that, you know, as for Hangzhou Changjiang, which is the one to do with the investor, my lady, you know, the JPLs are saying for that entity alone that on the first voting of the restructuring plan, there were insufficient votes. And so now that what the JPL say, to quote, may arrange a second voting of the plan in due course. All I'm saying to you, my ladies, is that because there are so many entities involved, many of which are subject to formal insolvency procedures with different persons, when you look at the email that's extracted in the skeleton, one ought to appreciate just at a very high level how many people actually need to have their say in order to make this a viable proposal. So these are the facets of the evidence, my lady, I would say, which go to the point of viability, and the court needs to weigh up in the exercise of discretion whether it's worth, you know, spending further time investigating it. That's all I want to say on the evidence, my lady, and if I can just address you on what is essentially our fallback position.
Okay.
It seems to be accepted, my lady, that if you are minded to grant an adjournment, I would suggest that you ought to keep the feet to the fire on this, because it's either going to happen very quickly and better evidence is going to fall out, or we're going to come back to you, probably likely by consent, I would say, and say this is not realistic, or with the benefit of better evidence, because obviously we haven't had time to have a say on it, that this is not realistic, and therefore the only alternative is a winding up order. So I say that if you are minded to grant an adjournment, you ought to make it very clear to the parties that, well, one, I think for the benefit of the future, that, you know, the evidence that was put before you was incredibly light, ought not to have happened on such a last minute occasion, and clearly needs to be better. And that you want to hear again in a couple of weeks' time the meat to the bones of the restructuring proposal. And what I mean to the meat to the bones, my lady, is that you should require current accounts of the company be produced, a proper workable plan for the future, and an indication on better evidence, you know, one, whether it's achievable and what needs to take place in order for it to be achievable, and whether, if it is to occur by a scheme of arrangement, whether it's going to have the support of 75% of creditors. I also say, my ladies, is that you can see from the correspondence, we've repeatedly asked for it, but we would certainly like full provision of what the JPL's fees look like. And if this is to be a serious exercise, there ought to be an estimate of cost of what this looks like in the future. Because of course, my lady, is if people are going to spend serious money trying to put what looks to be a complicated proposal into effect, we ought to know up front what sort of cost we're looking at, because of course, if it falls on its face, that's further money down the drain, my lady. In respect of, so I would say number one, my lady, it should be a short adjournment, and you should certainly be encouraging proper provision of information, and we would ask for it, my lady, so that we can make proper submissions to you based upon the evidence, what that proposal looks like. And the JPL should have this information at their fingertips, my lady, I would say. Thirdly, my lady, I would say that if you're inclined to grant an adjournment, all that you should do in respect to the substitution application is adjourn it. It ought not be dismissed, my lady. And it's important because if you dismiss our application and you have a majority creditor keep coming back to you and saying, I want an adjournment, I want an adjournment, I want an adjournment, we won't have an opportunity to step in and say to you, my lady, no, on the evidence, I can persuade you again on the exercise of discretion, there ought to be a winding up. Otherwise, it leaves my client with no remedy to seek a winding up order. So that's where we get to my lady. We would say, in summary, that there's a good case for a substitution order in light of the history. Of course, it's I would accept it's not a usual case that you have a majority creditor coming to court and an opposing faction seeking a winding up order, but it's justified because there are established principles for granting an adjournment, my lady, and I say on the evidence they haven't been discharged, and where another creditor has standing as of right and no one's disputing that. The rule of substitution is there to provide for these types of scenarios, my lady. And in the alternative, if you're not with me on that, as I say, adjourn our application, have a short adjournment of the petition, encourage.
As a short adjournment.
I would say it ought to be in the vicinity of more like 2-3 weeks, my lady, because we're sort of beginning of October, then we get into I don't know what your availability looks like, but we're sort of approaching Christmas, my lady. And if we start to head into that territory, I'm sure it just makes it difficult for everyone.
I think Mr. Tucker was proposing that we come back 1st of January.
Yes, I would say, well, it's very interesting, my lady. The JPLs, of course, are not advocating an adjournment to January. They're advocating, I think, 4 to 6 weeks.
I would just clarify, what I was saying is that the long stop date for implementing the presently proposed restructuring is the 1st of January. And so.
Yes, sorry, I didn't misunderstand that. I just misstated it. Yes, I did understand you. Thank you.
My lady, is now an appropriate time for me to make certain submissions to you on a couple of points, or
It may be Mr. Watson. Is that?
That's all I have to say.
I didn't want to cut my learned friend short. So
Yes, Ms. Hayworth, it is appropriate for you, so I can address no.
I'm grateful, my lady, and I certainly don't intend to make particularly protracted submissions, noting the time and also the points that the JPLs wish to make. The first point I want to address you on is the criticism by Mr. Watson as it relates to the timing of filing. I can only speak, of course, as it relates to the JPLs, but there was certainly some a lack of clarity on the part of the JPLs as to whether or not indeed the substitution application was going ahead. And I say that because there was a directions order made by the Honorable Mr. Justice Mussenden in April, which the first of which called for certain evidence to be supplied by the petitioner, but there was also quite a bit of an exchange of correspondence back and forth about the dates. Mr. Watson, not surprisingly, given his submissions in this matter, not wanting to wait until today to have this hearing and wanting to have it significantly sooner in July, and indeed the petitioner's counsel indicating that they weren't available. We did ask for clarification on a couple of occasions with the court and the petitioner in the instance of not having seen and any evidence being filed, but only recently had that clarification. And by recently, I mean, quite literally the end of last week, right before the restructuring was received. So there's certainly no intention on the part of the JPLs to put in evidence at any late stage to keep anyone from having a fullness of time to consider it. But we have to consider both that this substitution application was ongoing, and simply the JPLs take a neutral position in that, and it wasn't entirely clear what the position was on that. And we also have to consider when the restructuring plan was received, which is well established between the parties. It is also interesting to note as well that there's criticism leveled against both the JPLs and the petitioner for the filing of their evidence. But if we look at the directions order, for example, something like skeleton arguments were due on a specific date quite some time ago, and we note that Elise's counsel only provided those in conjunction with the petitioner yesterday evening as well. So the lateness of filing really does sort of span the group, if I can put it in that way. Secondly, as it relates to the JPL's participation in these hearings, I mean, obviously the JPLs have views as it relates to the current restructuring, which has kind of emerged, the proposal and the adjournment, which have been expressed. But I do want to be clear that again, in large part, our participation in what has become, sort of now a hybrid substitution and adjournment application, but was very, very much in the beginning a substitution application, was in large part due to criticisms being leveled by Mr. Watson on behalf of his clients, which the JPLs felt, they had that, no alternative but to respond to. Quite serious and substantial, criticisms regarding the costs that they've incurred to date and the provision of documents. So I just want to make that point that and Mr. Watson, I think, continuously has the difficult position to argue that he complains about the level of costs being incurred, but yet his complaints generate more time and energy to address them and thus incur more costs, which is a difficulty with the complaint that he makes. I will submit for the avoidance of any doubt whatsoever that the JPLs do believe that they have acted entirely appropriately in this matter. As my learned friend, Mr. Tucker, has made the point, and I certainly would agree with that point, this is a complex provisional liquidation matter that necessitates time and energy to be spent and costs to be incurred. But certainly wherever possible, the JPLs have sought to limit those costs to seek, discounts on rates, et cetera, wherever appropriate, to minimize those costs. And far more importantly, I think it's of note that they haven't been paid anything to date. And I do think that is an incredibly relevant submission. Additionally, there's a few points I want to raise in relation to the restructuring that proposal versus a consideration of winding up. Interestingly, again, Mr. Watson makes a submission which I find, again, he sort of sits on on the edge of a knife's edge or a pin, if you like, trying to make this submission. He says that a winding up order, one of the benefits to it is that it doesn't shut out restructuring in principle. So he's asking the court to make a winding up order with restructuring being in principle, but yet criticizes a proposal that is actually in front of the JPLs and the court right now, and criticizes that due to the lack of detail that's been provided. I find that a rather difficult submission to maintain. Indeed, he talks about as well that there's no evidence of there being a zero return. On the contrary, my learned friend took you to, and I don't propose to take you, my lady, through it in any detail because it's there, but certainly at paragraphs 22 through 24 of Mr. Klingerman's evidence, he takes you through and explains the cash balance position as of the 2nd of September, but certainly goes into as well with the JPL's fees and costs. They have yet to draw a single dollar and reflects the fact that there is a shortfall. So I think that is an evidence, and I think that is something that you can and indeed should consider in making the determination today as it relates to whether or not to grant the adjournment in this matter. I think the other point to be made here is Mr. Watson indicates he took you to 4.3 of the restructuring plan.
Yes.
And said that nothing can be done without his client's consent. He made that assertion and said that you should rely on that because there's no evidence to the contrary. I take quite the opposite position. I think it's trite actually that debts can be assigned without the debtor permission. Obviously, individual sort of concerns and considerations about what the agreements were that led to that debt have to be considered, and certainly would be considered in the fullness of time. But to suggest that you should accept that Elise's consent is required simply because there's no other evidence before you, I think is misguided. The other thing that my learned friend, Mr. Watson, mentioned several times, and indeed has mentioned on previous occasions as well, is that without his client's support, 75% support, which such that you would need for a scheme of arrangement, is tenuous at best. My lady, again, this presupposes a scheme of arrangement. A scheme of arrangement is of one of many different forms of restructuring that can be considered. So, my lady, I'm keen not to belabor the point. I think you have the JPL's evidence in this case. They've outlined. The only other point, that there is one more point that I do wish to make. Again, the criticism about filing and timing. I do think it is quite important for the court to have a current status of the provisional liquidation, and not 3 months ago or even 3 weeks ago in considering this case. We do think on behalf of the JPLs that it is entirely appropriate to update the court on the current status, which we've done, so that the court can take that into consideration, because particularly in matters that are as complex and involved as this one, things can change in very short order. So all that said, my lady, you have, I think, the evidence and the submissions on behalf of the JPLs as it relates to their conduct to date, the restructuring plan, which indeed there are some concerns and it will have to be considered. But I think the position is at the moment that the JPLs certainly don't take any objection to the idea of a reasonable adjournment period to consider those, because the alternative is a zero return for creditors, which would certainly be undesirable. And those are my submissions, my lady.
Thank you very much. Mr. Tucker, did you want to?
My lady, do you mind if I reply? I'll be all of 2 minutes, if I may.
Okay. Mr. Tucker,
Yes.
I'll hear from you afterwards. It may be unusual, but it might also be
Yeah.
practical. Yes.
My lady, with just a couple of quick points. It was a bit surprising to hear mention that there'd be no scheme arrangement. Surely the JPL is in a position to tell you how this would be implemented by way of a restructuring. So if it's not a scheme of arrangement, what is it, my lady? And that, is obviously, it stands out as an obvious concern in favor of us. This proposal's been put up and you don't even have sort of a broad picture how it's actually going to be implemented, my lady. That's the first point.
Mm-hmm.
The second point, my ladies, is that the criticisms in respect to the JPLs are very focused. When you read the correspondence, we've been asking for very specific information, my lady. And when you look at that correspondence properly, you'll see quite clearly it hasn't been provided in my submission. Obvious things like you don't have a full set of accounts before you, my lady. So we're not criticising the JPL's conduct in sort of an entire vacuum, my lady. It's more so targeted towards that creditors need certain provision of information in order to be able to make submissions to you, in court. That's the criticism, my lady.
Mm-hmm.
The last point, my ladies, is that you can consider the matter for yourself. But we would say if the court clearly makes directions, that they should be obeyed. It's not a question of me needing to do anything about it. If you wanted to file evidence in response to it, and you'll see large parts of the Klingerman affidavit are responding to what's in the April affidavit, that ought to have been done, my lady. I accept evidence in respect to the restructuring proposal, that there's no choice essentially but for it to come very late. But in respect of anything else regarding, position of the company, its financial affairs, etc., to us, there's no reason why that ought not to be put forward. And the final point, my ladies, is that there seems to be some criticism that we ought to have filed some skeleton argument. Well, if no one was going to file evidence and no one was going to file skeleton arguments, we would have turned up in front of you and said, look, there's no evidence, there's no restructuring proposal. You wouldn't be baffled, and it's clearly a case for a winding up order.
Mm-hmm.
So we would say we have clearly done the right thing. The rest haven't had their houses in order. That's all I have to say, my lady.
Thank you very much, Mr.
Thank you.
Watson. Mr. Tucker?
Lady, I will be quick. The first point that I'd like to make, I've got 5 points. The first point I would like to make is in relation to the criticism of the petitioner in not having filed evidence. The suggestion is that there was a breach of the court order. That is not the case. The order dated the 29th of April, 2021 states that the petitioner shall file and serve affidavit evidence in response to a release, if so advised. Our position has been since the outset that this application is absolutely hopeless because of the substitution application is hopeless because of Mr. Watson's comparative debt to the estate, which was proved in a prior reported decision of this court. Our client was not prepared to incur the significant cost of reproving matters that are the subject of a judgment of this court. Secondly, the filing of evidence on the 14th of May 2021 for a hearing that was going to occur in September simply was pointless, which was always our position about this application, which was that by the time the deadlines arose for filing evidence and going to a hearing, the restructuring would still be continuing.
Mm-hmm.
And it's a
Wouldn't have an updated, the court would not know what the
precisely. So, and indeed, our client wouldn't know the position that they take on whether or not they seek a further adjournment of the petition, which is the critical point. is until the actual petition comes on for hearing, it's difficult to know whether as a creditor, based on the prevailing circumstances, the correct thing is to seek a winding up order or an adjournment. And so from our position, there can be criticism, and no doubt it is unsatisfactory that this is to be in or it's less than ideal, I would say, to be in a position where we're considering information that was received 2 days before. But such is inevitably the case in these restructurings. Generally, it's not as bad as it currently is, but it's precisely for that reason. And this goes to my second point, which is that the JPLs have come under considerable criticism from Mr. Watson on the basis that they haven't provided financials to them. I think that that's deeply unfair. The JPLs have prepared reports and provided reports on the 15th of December, the 9th of April, the 21st of July, the 5th of August, and the 28th of September that go into pretty significant detail about what they are doing on a day-to-day basis. They have also, in Mr. Watson's own evidence that he pointed to at paragraph 78, at pages 78 and 79, provided the best evidence they have of the prior accounts and the receipts and payments since they took over the liquidation. The combination of which is to give a picture of the current liquidation. The only thing that Mr. Watson can say he doesn't have is perhaps a valuation of potential claims or assets, but of course that is not something that can be ascertained except in the context of a particular restructuring proposal or a winding up, neither of which in this particular context has been crystallized. So I would just say the criticism of the JPLs from the petitioner's perspective is unfair in the sense that in his own evidence and in the affidavit of Mr. Klingerman, we can see that the court has been routinely updating in significant detail about the ongoing attempts to preserve the value of the assets and indeed give Mr. Watson's client an opportunity to evaluate for themselves what they think the value of those, for example, the equity holdings in the Hangzhou factory are. So I'll just leave that because I don't think it actually goes to the point. Which brings me to my third point, which is the Lithi Holdings case that Mr. Watson relies upon. We say this case is entirely inapplicable, and a fundamental error has been made here. This case and the criticism levied by Justice Harris, which I'm very familiar with, and this court's very familiar with, related to an application by the company itself.
Yes, thank you. I actually wanted to, thank you very much, because I wanted some context. I think that's very important.
Hugely important.
Yes.
And in particular, what we say about that is that we say that.
So this was, before you go on. So this was a case where the company was resisting the efforts against it to be wound up.
Correct, which Justice Harris has taken issue with in the past to say, and the actual Hong Kong authority for whether the test for an adjournment is actually Ping An Holdings, and it goes into detail about what one does when there's a controversy between creditors, and the position is demiglass. It's the same, but if a company seeks to overcome the views of creditors, yes, it must have a plan that is so coherent that it demonstrates that effectively creditors don't know what's in their best interest. And often the justification for that is the company knows more about itself than the creditors do, and it will say, look, if you give us time. But that case is not authority for the proposition that the majority of creditors coming to court must have with them specific things. I do not doubt the proposition that the court must consider the feasibility of proposed restructuring. But what I say is that where there's a majority of creditors before the court, the best proxy, the creditors are taken to know what is in their best interest, unless the contrary be shown, which Mr. Watson has not done here. And that takes me to my fourth point, which is benefit. It sounds like Mr. Watson says the benefit to a winding up is there will be a committee of inspection and we will have rules. Firstly, a committee of inspection is elected by majority of the creditors. And given Mr. Watson's position, which we consider to be unreasonable on this application, it's very unlikely that we, being the majority of creditors, would elect his client to the committee of inspection. So it's more likely that we'd elect some other creditor who we deem to be more reasonable in the circumstances. So the fact that there might be a committee is not a benefit to him or his his client. But more importantly, the mere fact that there is a committee of inspection once a winding up order is made does not override the fundamental purpose of a winding up proceeding, which is to produce value to the creditors that sit on that committee. And contrary to what Mr. Watson says, there is evidence here that the return is zero if there is a winding up order.
Yes.
The mere fact that his client could potentially sit on a committee, which we say it wasn't going to happen, but sit on a committee is not a benefit in the terms of the case, in the terms of the authorities. So then I would like to go to my fifth point here, which is
Before you go on to the fifth point, and please don't lose it. Why do I not know? Well, I suppose the timeline would answer the question, but what is the likelihood of the court being provided information as to what the position is of the other unsecured creditors?
Milady, if what is sought is to have the views of the other creditors, our client, I have no doubt, would be able to ascertain those views, has relationships with the other creditors, and I'm not saying that without evidence. That is clear from the FDG electric vehicles ruling, which is in our bundle, and the prior JPL's informal creditor committee discussions, and we could come back to court with their views. I think that it's fair to speculate.
Thank you.
Yeah. So just to close that point out, the idea that a benefit is simply that the winding up rules are engaged does not outweigh the fact that the only proposal on the table requires that we have no winding up, and indeed there's 3 months in which, at least in theory, the listing status can be saved. So that's the fourth point. And then the fifth point is one of principle, which is that Mr. Watson says that there's no authority. We've pointed to no authority where something's been adjourned for 18 and a half months. First of all, that's wrong. Up Energy itself.
I was going to say, I did a ruling in Up Energy.
You did, which is precisely what I was going to point to, which is that in Up Energy, which is the citation for that case is 2018 SC BDA 76. The court considered a petition that was presented. In fact, I appeared on the first hearing of that petition on the 6th of May, 2016, and it adjourned a petition that was on the 19th, in their ruling, in the lady's ruling, that dated the 19th of November, 2018. And in fact, my understanding is that petition continues to be adjourned. I'm not sure, or it was it continued for some time, at least after that. But of principle in that decision is something directly relevant, not only to his submission, there's nothing before the court.
The views of the minority of unsecured creditors versus the majority.
Correct. And in that case, Milady said something very important in paragraph 48, which is that it says, in my judgment, the court need not at this stage satisfy itself onto the certainty of success of a scheme of arrangement in order to adjourn the petition. A reasonable prospect of success will do. It's sufficient to establish in deciding whether to adjourn the petition, the majority, even if not up to 75% of unsecured are desirous of adjourning in order to support the JPL's further attempts of restructuring. If the current majority, brackets 51% plus of the unsecured creditors, are reasonably optimistic that a scheme of arrangement at 75% majority of voting creditors claims is attainable, the court will usually decide in favor of the wishes of the unsecured creditors. And this was the case when the substitution application was issued. It was the case at every prior hearing, and it's why we say that Mr. Watson's entire premise, the entire premise of his application, that he can overcome the views of a 63% creditor, is misconceived, particularly in circumstances where his client does not have a blocking stake in any scheme, or at least he hasn't put that forward. He doesn't say his client holds 25%, a sufficient majority to block a scheme. So a majority supports, and so from our perspective, the fifth point is that the idea that there's nothing to say the court's ever done this before is entirely wrong. It is, in fact, something that the court routinely deals with. And in the specific case, which the lady handed down judgment in 2018, which has not been doubted and in fact has been applied in practice and decisions that didn't result in rulings, the approach is to go with the majority. So all of that, those are my 5 key points in reply. To wrap up, I think the only open question is Mr. Watson started his submissions by doubting whether or not the table of liabilities in the restructuring proposal is accurate, which we say is it's ridiculous because the ruling, which is in the bundle at tab 3, which is 2020, it's in the matter of FDG electric vehicles. And the citation is 2020 BDA LR 39, goes into significant detail about the various stakeholders. But importantly, it says, it confirms a paragraph.
July 2020 ruling?
Yes, my lady, which you will recall was hotly contested. And in that, even the company management who were removed on the basis that they could not be trusted to run the restructuring admitted that we were creditors. And in fact, the court found that the company was unable to make certain principal and interest payments on its immediate financial obligations to the approximate tune of 1.6 billion Hong Kong, of which 1.3 billion is the subject of litigation, rendering necessary the issuance of shares in the company. So, and then at 75, the court found that the court considered the debt held by my client and Elise and certain other creditors, and it came to the it considered evidence that the total debt of the owed to creditors supporting the overall total was 3.2 billion. So what we would say is that simply relying upon the prior decision of this court, which considered there was dispute about who supported what. In that case, in fact, Elise says they didn't support the removal of the JPLs. That's immaterial. The point is that the numbers in the prior decision of the court reflect the numbers in that table, and the JPLs are here. They can tell who would ultimately be tasked in the winding up Mr. Watson is seeking to determine proofs of debt, have not said that our calculation of claims is wrong. And in fact, it's on it from our perspective, it's unimpeachable. But again, since we're a 63% creditor, even if it were off by 100 million Hong Kong, it would still we would still have multiples of Mr. Watson's debt. Yes. So that's kind of the wrap up point, which is that I don't understand how I think that the court can be confident that although the numbers appear in this restructuring proposal, the fact that they have not been challenged substantively by the JPLs at this hearing and in their evidence and are consistent with our clients' petition debt. The petition debt sets out why we were owed, and we've filed multiple affidavits verifying that affidavit that debt. It's sufficient to show that our client's debt is what we say it is, and therefore 63%. So my lady, that's our reply submissions. I don't think it is necessary on the substitution point. Mr. Watson says, "Oh well, his substitution application is important. It ought to be adjourned." We say that there is no circumstances in which it could be successful. And the reason is we will always be a majority of the creditors. And our client will, in our view, always be, if there is a circumstance in which there's no proper restructuring proposal or the winding up will be pursued by our client, and it may be that it should be adjourned to that point, but if it is dismissed in circumstances where our client is seeking the winding up because it's concluded that that is the correct time, future date, if indeed we are successful in obtaining an adjournment today, we would say at that stage that it should be dismissed. But at this stage, and when it was issued, it had no prospects of success. And I don't think it's necessary for us to address the specific reasons, which there are specific reasons why it had no prospects of success at the time it was issued, which relate to the prior letter agreement, but it's not necessary to address them today. We can address those when it comes time to deal with the substitution application, if indeed it's adjourned. So, my lady, that's wraps up our submissions. Hopefully, I've gone through it not too quickly, but in time for us to get to lunch.
Let me just ask you in terms of a return date. What are you proposing?
We would say that we would not be able to oppose a return date that's in the 4 to 6 week window that the JPLs have indicated is appropriate, given their views on that. And so I think the so 5 weeks would be the 4th of October. And 6 weeks would be the 11th of November.
5 weeks would be the 4th of October. That's not.
I
Sorry,
think
4th of November.
Oh,
like the 4th of November is Monday. What?
That's not what I'm asking for.
Okay.
To be clear.
nothing.
But no, that's sorry. I think the 4th, but the first Friday is the 5th. The first Friday is the 5th of November.
The 4th of October will be just fine.
Yeah. Thought you might like that.
Right. Okay.
And I should say it's our expectation that it will be able to be dealt with in the Friday list on that day, as everybody appears to agree. The circumstances of the company there will be sufficient time for the circumstances of the restructuring proposal to be properly investigated.
Right. All right. This is my decision. I think that the court ought not to disregard the evidence from the JPLs, from Mr. Klingerman, of the company's cash balance position as of September 2021, and the dim view held by the JPLs of the profitability of an immediate winding up order. That evidence is not substantially challenged before me, and so I think it is reasonable with this court at this stage to have real and grave concerns as to the effects of an immediate winding up order. In terms of the restructuring plan, I think that the evidence shows that there is a reasonable prospect that a restructuring is viable. And in coming to that view, I also attached significant weight to the views expressed by the petitioner, who is, for all intents and purposes, the majority, represents majority of unsecured creditors, with a overall debt in the approximate sum of 1.3 billion Hong Kong dollars, representing 63% of the overall indebtedness of the company. I have to contrast that against the position of Elise, which before me, there is enough evidence for me to be satisfied as I was when I was looking at the issue of a application for removal of the previous JPLs, that Elise is a minority representation of the unsecured creditors in the percentage of an approximate figure of 12.81%. These are factors which the court has, as a matter of principle, always had regard to, and I think I have no basis to depart from that very standard approach. I do cite the decision and the ruling that I delivered in the case of Up Energy at paragraph 48, I think it was, in terms of the court being satisfied that there's a reasonable prospect of a viable scheme of arrangement. And I need not be satisfied at this early stage that there is made out a 75% requisite majority. A broad appearance of a majority will suffice at this point. And additionally, I think that Mr. Tucker's argument that there is no evidence before this court that Elise has a blocking stake in any scheme of arrangement is also persuasive and relevant in factoring into consideration whether or not the court should take a more radical step of substituting and proceeding to making an immediate winding up order or adjourning to see the development of what is currently on the table as a viable restructuring plan. And so for those reasons, I do grant the application by the petitioner for an adjournment. I will adjourn to Friday, the 5th of November, 2021, this year, at 11 a.m. Now, in terms of the substitution application, Mr. Tucker says that there's no circumstance in which that application could be successful. And admittedly, that argument has some force, but I will, I think, approach this more conservatively and adjourn the substitution application. It seems to me, from a practical standpoint, that if there is a successful restructuring, then the substitution application will naturally fall on its head. And even if there is not, and the case proceeds differently, where I do not grant any further adjournment on the petition and an immediate winding up order is made, then once again, the goal of the substitution application would be achieved. And so I see no reason and I see no prejudice caused by my adjourning that application at this point, sine die. Or I should say perhaps to the same return date, to the 5th of November, 2021. I think that's probably the better approach.
Yes, my lady, I would.
Yes, thank
You
you.
go first, Mr. Tucker.
I would just say that if two points. One is that if on the 5th of November our client is seeking a winding up order, we would then be also seeking for that for the substitution application to be dismissed with costs.
Okay.
And a second point is we suggest that the costs of the substitution application be
Reserved.
yes, my lady.
Yes. I think it should be reserved, as given that I'm adjourning it.
Yes, my lady. The only other thing, my lady, for consideration is whether, in order to bring structure to the next hearing, my lady, whether a provision for timetable of evidence should be made.
Actually, what I would like to do is, thank you very much, Mr. Watson. That's helpful, because I did have it in mind that I would like to have some evidence as to what the position is of the other unsecured creditors. I also should give you the opportunity, Mr. Watson, to file some reply evidence that you complained your client did not have the opportunity to do for the purpose of this hearing.
Yes, my lady. May I suggest, my lady, that if some of the concerns we had can be addressed in evidence from the JPLs, obviously raise things such as accounts, fees, list the creditors and their amounts. That may negate the need for us to file further evidence. And of course, it'll be coming from the JPLs, my lady.
Well, I'm going to want an updated position. I think if the hearing of 5th of November does in fact materialize, I would expect that the JPLs would have before the court, would be filing before the court some update as to what the position is. I know you're concerned, Mr.
Yes.
Watson, in your complaint that you've not had sufficient detail in terms of the company's accounts, and you don't accept the certainty of the cash balance, the evidence of the cash balance position, and so forth.
My lady.
Yes. I was just going to suggest, in light of that, my lady, to try to bring structure to the hearing. That's why I say there ought to be a timetable.
What are you proposing? Because
well, I appreciate that we should probably give as much time for the restructuring to materialize in light of the adjournment. So perhaps the Friday before the hearing, my lady, perhaps the JPLs and the petitioner can put whatever evidence they want to put on. Of course, it's just going to turn into a winding up. Then I'm sure by that Friday, we'll all know what the position is, and maybe no evidence gets filed. And then, say 3 days before the hearing, we put on any reply.
That sounds reasonable to me. Mr. Tucker?
I think that's fine from our perspective. We're happy. I think that the specific wording of the order that we've obtained in prior cases is that the petitioner shall file evidence in support of a further adjournment, if any, by date, and if you want to, we could have the petitioner and then the JPLs. That's so.
Then the JPLs would just update the court on the position.
Correct.
That would be the Friday. That would be 7 days prior to the return date.
That's a reasonable approach, consistent with prior cases, my lady.
Okay, Ms. Hayward.
Apologies, I was struggling to unmute. I don't think that's a difficulty from the point of view of the JPLs.
And then Mr. Watson would have 3 days prior to the hearing to file any response.
So we'll try file by close of business Tuesday.
Sorry?
Yes, we'll try file by close of business Tuesday.
I don't want to give the dates. I have to be honest. If for whatever, we have to accept, given the environment of coronavirus, who knows why a hearing might push forward a week. So I'm just simply going to say 7 days prior to the hearing, evidence from the JPLs and from the petitioner, and 3 days prior to the hearing, we should hear, you have leave to file any reply evidence. Okay. And, but I do set the return date for the 5th of November at 11 a.m. by Zoom. Okay. Unless there's anything further, and I've reserved cost of the adjournment, costs in relation to the substitution of the substitution application.
Thank you.
My lady, the adjournment application was opposed. We would seek the cost of our relating to the adjournment, the opposition of our
Any
adjournment.
reason why the petitioner should not have their costs? They were successful in the adjournment application.
My lady, we were going to turn up today in any event, so some costs would have been incurred. I don't think it's fair, my lady, in circumstances where evidence has come in the day before the hearing, my lady, and I would say it is right for the court to hear views of different creditors, particularly in the circumstances of what is an exercise of discretion, whilst you've obviously granted in favour of an adjournment, my lady, the costs in effect go hand in hand. And so I would say that the appropriate course is very similar to what you've done in respect to the substitution application. You should reserve the costs, and then we'll see where this all ends up.
Well,
Because of course,
that's not quite true, is it? Because if the adjournment application had been agreed, we wouldn't have gone through any of this hearing. There would just simply have been a consent.
well,
to the list
that's
and to
not
come
quite
back.
correct. That's not quite correct, my lady, because the petitioner was seeking an adjournment through till January next year. And there's a draft form of order that was provided to that effect, my lady. You've agreed, you've granted a shorter adjournment.
What's the detail, though, in terms of return date, the adjournment of, I mean, what he was trying to achieve was an adjournment of several weeks, some 4 to 6 weeks, and that's effectively been achieved.
And the fallback position only arose in the hearing today and was rejected.
Which, my lady, I think the position is simple. We had proposed an adjournment. That proposal was open from the moment that we had provided our evidence. And Elise, having considered the evidence and decided to push ahead, and that necessitated the filing of skeleton arguments and a half-day hearing. So we think we should and to be clear, Elise was seeking a winding up order today, and they didn't obtain it. So we would say we're the overall winners of today's hearing, overall successful party, and in the ordinary way, we should have our costs of today's hearing.
And my lady, I would say, we also have been necessitated to file evidence in circumstances where, had the adjournment been agreed, we wouldn't have necessarily had to. And additionally, I would put the marker down that we've had to file evidence to respond to issues of complaints and allegations made in relation to the JPLs in the context of the substitution hearing, appreciating your position about the costs in relation to the substitution hearing. But I would put the marker down that in the event that doesn't proceed or isn't successful, certainly the JPLs would be looking for costs in that regard, and would be looking for their costs in relation to the adjournment.
Yeah. Okay.
Well, lady, can I just for one moment? The way in which the evidence transpired was Mr. Tucker sought an adjournment, and then the JPLs informed us they were going to file evidence. It obviously wasn't until we saw that evidence could we consider the position. So we didn't cause the costs we actually didn't tell what our position was until we saw the evidence of Mr. Tucker and the JPLs, because we didn't know what the evidence was, my lady. So we didn't cause the costs of the JPLs filing their evidence. In any event, my lady, their costs will obviously be costs of the company, we would say, and that's perfectly proper. In respect to Mr. Tucker's costs, if it turns out, my lady, that this proposal is not viable, we will be proven to be right, my lady.
No, that's not the test. The test is whether or not today this proposal was sufficient to justify an adjournment, and that was the ruling. We were successful. The court doesn't look back with the benefit of hindsight to determine whether or not costs should be ordered one way or another on an adjournment. That's just as a matter of principle wrong. We say we should have our costs.
All right, let me just come over to JPL for a second. Ms. Haywood, sorry, let me just make sure I've understood. Your position in terms of costs on the adjournment application is what?
It is that we had understood certainly that an adjournment was opposed
Yes.
by Mr. Watson, and
The
felt-
filing of that affidavit evidence, you say, was as a result of the position taken by Elise opposing the application for an adjournment.
That's not right.
Sorry, can you-
I'd like to
please,
respond to it.
I'm addressing Ms. Hayworth. I only want to hear from Ms. Hayworth, please.
Apologies. Thank you, my lady.
It is twofold. I'd say, my lady, I'd say that's correct, that it was to respond to the adjournment, but indeed also it was to deal with the points raised in the substitution application
Yes.
in relation to the JPLs.
All right, okay. All right. Mr. Watson, I'll allow you your final word.
Yeah, that's my idea. I'll just be very brief. As I say, my lady, and you won't find any email to other effect. We did not put a position, my lady, until we received both the evidence of Mr. Tucker and Miss Harworth. We weren't asked, and I'm sure both would say we didn't say we wanted substitution. We looked at both of their evidence, and skeleton arguments were exchanged, my lady. That's the proper version of events. If I'm wrong about that, either of them can say, but I certainly didn't say to Mr. Tucker or his colleagues or Ms. Harworth that we were going to be opposing an adjournment before evidence was filed. That's simply not correct.
Thank you. It seems to me very clear that the application for the adjournment by the petitioner was opposed. It was argued, it was hard fought, and it was lost. And whether the court was going to adjourn to the 5th of November or to a date in December or July is immaterial when you look at it more holistically in terms of what we've been doing all morning. And
Yes.
effectively, we've been arguing against the adjournment of the petition and for an immediate winding up order is really what this morning was about. And it seems clear to me that Elise was unsuccessful on that.
Yes.
And so I do grant cost to the petitioner to follow the event in terms of the adjournment application. I'm going to reserve cost in terms of the JPLs because I think that I should really look at the subject of costs when I come to looking at the substitution application. It may be that I think that they should get some portion of the cost also for the adjournment application, but I won't make that determination now. I'll reserve and let the JPLs address me more fully when the time comes.
Thank you, Heidi.
Of this substitution application. Okay. Unless there is anything else, I will adjourn.
Thank you very much, my lady.
Thank
Thank you, my
everyone
lady.
for your very helpful questions. Thank you.
Thank you.